Hi, good evening. This is Rahul Reddy from Reddy and Newman PC. We are back on Facebook Live as usual every week on Tuesday at 5 o'clock Central Time. We're going to have some question and answers about immigration law. Along with me is my business partner Emily Newman and also the blog writer of the immigrationgirl.com. Emily?
Thanks for joining us today. So the big news in the last week was the H-1B cap. The window opened and closed in the first 5 business days as we expected. We don't have any announcements from USCIS other than we know for sure that they received enough petitions to fill the lottery within the first 5 business days. We expect, based on previous years, we should have an update probably by Monday regarding the number of petitions that were filed, as well as a confirmation that they have run the lottery. And then shortly after that, we should start getting our first receipt notices in the mail.
Emily, did you set that on Monday we will be able to hear the information on how many applications have been received?
That's expected. No guarantees. USCIS does different things every year, but based on the last year, I think we'll probably get an update on Monday.
Monday, okay. And Emily, how soon do you think so we're going to receive the receipt notices? As a lot of people have filed in applications, they're very curious to know, based on our experience last year and the previous year, how soon they are going to have the receipt notices issued or when the checks are going to be cashed.
I think what was weird last year is we actually saw a few checks cashed before they even made the announcement that the lottery was done. So it could be as early as next week we start seeing a few checks cashed, but it'll pick up probably late April.
I can assure you, I checked the bank today. None of them have been cashed for the new quota. But hopefully so, we are going to have that in the next year. Please also do believe that there will be a lot of fraudsters who will be faking the news with regards to, oh yeah, this one, that one, they'll fake it. Please be very careful on the news that spreads out very thoroughly, though. Just be careful. Last time we had some announcements that were actually done in 2015, but they published as if that it's going to be done in 2017. Emily, what is your guess with regards to how many applications are pending with the New Year's quota?
I think my previous predictions were somewhere around the 180,000 mark, maybe a little less than that. Definitely less than last year, but I don't think it'll be that much less.
I am betting to be at 160,000. So if I lose, I'm going to pay $1,000. Oh, sorry.
Whoa! All right.
Sorry, $1. I mean 1,000 Ethiopian dollar, not in US dollars. $1. You'll get $1 if you come close to. I'll pay you $1. No, I don't bet that much. I don't have that much money. What do you expect, Emily, with regards to the new memo that came out and published on March 29th with regards to the duplicate filing? We know that there are some people who have done duplicate filings, and Reddy and Newman PC has always been advocating not to file these duplicate applications. What do you think so this year the USCIS is going to do differently?
I think they're going to widen the net and consider multiple petitions as duplicate petitions more often. I think they're wise to the situation where documentation looks similar, the end client is the same, the attorneys may be the same for the 2 different companies, and so I think they're going to be looking a lot more closely at petitions that may be actual duplicate petitions, even though they're filed by different companies.
I think so that they're going to have more scrutiny once they see 2 names for 2 applications on the same name. They're going to first take the money, that's what they told, and they're going to scrutinize both the companies that filed for these applications to see if any or all of them are any fraudulent applications. So that's what I am expecting. Let's go to some of the questions that came out. Mr. Radhakrishna has put a question that the job duties performed are level 1. Can we put this level 2 job, level 2 salary and get that H-1B approved?
Well, I think that you're required when the LCA is filed to certify that it's accurate, and so if it really is a level 1 wage job, you shouldn't be listing a level 2 wage. It's based on what the actual job is, and so that kind of sounds like maybe you're trying to circumvent the requirements or maybe inflating what the job actually is in order to get through the specialty occupation scrutiny. So I think that's a problem.
Emily, the question came from Facebook is that, can you update on the H4 EAD status? Can they apply for the H4 EAD right now? And if they get an H4 EAD, when and if the H4 EAD gets cancelled, can they still continue working on their EADs?
Right, definitely now it's still good. You can still file for it. They're still giving the full approval period, whatever's on the H4 and the H1B. We are expecting a proposal sometime maybe in June. These things are often delayed, so it may not even happen in June. Remember, whatever does come out, it's just a proposal. It's not the end of the road. So even if they propose to eliminate the H4 EAD, it still exists until a final rule is actually implemented and takes effect. That will take many more months, at least 6 months, maybe even a year. I would expect there to be litigation on top of all of that. So I would say that the H4 EAD is not going anywhere anytime soon. And even if it does, those that have valid H4 EADs probably will be able to continue those until they expire. This is a guess, but this is based on how the Trump administration treated the DACA recipients. Those EADs that were already issued are still valid. They're able to continue. They were even able to renew based on the litigation that's going on right now. So I don't think we're anywhere near the end of the road for the H4 EAD.
Prem has a question with regards to his H1B extension has been denied. Can he go back to India, whether or not he can file another H1B while he's in India? Will that H1B be subject to the cap? No, it will not be subject to the cap. If your first H1B has already been counted towards the cap and your extension has been denied, you will not be subject to the cap. You can file a consular processing not subject to the cap, and you should not have any problem with regards to the cap issue.
All right, we have a question about changing status from F1, say OPT or something with work authorization, to H4 and H4 EAD. Can you apply for them together, and is it possible to do it without any break in the employment authorization?
Yes, you can apply for H4 and H4 EAD at the same time. Most of the times, I would say about 98% of the times, the H4 and EAD is approved at the same time. If you have a EAD valid, which is a STEM extension valid, and you file for a H4 EAD, you can continue working on your STEM extension until the H4 is approved. Most likely, when the H4 is approved, the EAD is approved at the same time. So you don't need to have any break. There are very rare circumstances where the H4 and EAD are not approved at the same time when they are filed together. So it's a very likely chance that you would be able to continue working without any break.
I do think there's a problem there because the processing time of the H4 is so long that the OPT time might run out.
Yes. If you have your work authorization expired before the H4 and the H4 EAD is approved, then you have to stop working. The same case is applicable when the person is on H1B and he is filing a H4 plus EAD. They could continue working until the expiration of the H1B, but they should stop working after the expiration of the H1B, or in this particular case, OPT.
All right. What do you think of systems analysts? Do you think those are tough to get approved these days?
Yes, Emily, as we have noticed that in December of 2017, the Department of Labor has changed the definition of the system analyst, describing that only 47% of the system analyst requires degree, and the degrees they mentioned include the liberal arts degree. However, they dropped the liberal arts degree in March of 2017, but they still are, the Department of Labor contends that only 47% of the system analyst positions require degree. Now, why the degree is very important is that for a H1B specialty occupation, the position must require a specific degree as a minimum requirement. The Department of Labor, which publishes the Occupational Outlook Handbook and the ONET, they published with regards to the surveys done, what they have, that they are telling in December of 2017 that only 47% of the system analysts require bachelor's degree. Based on that, USCIS started denying the application. I have noticed that even if it's a level 3 job in system analyst, they are denying it. So you want to consider very carefully when you're filing with a system analyst. You might want to discuss with your lawyer, check the job duties if they're matching the system analyst. If the job duties could be, if you can get a different job with the same company rather than the system analyst job, that would be very ideal for you to move on to a different job than stick with the system analyst job.
All right. There was some news last week about ACICS. And what do you think that so ACICS lost their ability to accredit schools. So those schools that were accredited by ACICS all of a sudden became unaccredited overnight in December 2016.
That's right, December 12th, 2016.
Now all of a sudden, Department of Education comes back and says, oh, never mind, ACICS, you're good to continue your accreditation. So what does that do for those students that maybe lost out on the STEM OPT because they weren't accredited at the time they needed to apply their STEM extension?
Not only the Department of Education said that the accreditation is good for the ACICS universities, they also said that the accreditation will go back all the way to December 12th of 2016. On December 12th of 2016, the Department of Education mentioned that the ACIS lost its accreditation to the universities. There are many universities that were accredited in that. So they said you're not eligible for the accreditation from December 12th. Now on April 3rd, Emily, that was the date, that they said, I mean, most of the applications were already filed. If not all the H-1B applications were filed, they said that accreditation goes back to December 12th of 2016. So their degrees are considered to be accredited even if they graduated between December 12th of 2016 to current. However, most of the people, based on the advice of the lawyers, and of course we did it because at that time it was not accredited, have filed their applications in bachelor. Emily, what about those people whom we said that since their university is not accredited, they cannot file the STEM extension? What if they have not used the STEM extension, they are in a different status right now or gone back to F1? Can they use the STEM extension, or can they, if their OPT is valid right now, can they file the STEM extension?
So I think if they are in OPT right now and now the school is accredited again, they should be eligible to file the STEM extension.
I don't see any problem if the OPT is still valid.
Right. The problem comes in for those that OPT expired and they were not able to file the STEM extension. Maybe they went back to school. I think they would have to complete the entire program before they can be eligible for the STEM extension later on, because we do know that you can get the STEM extension twice now, right?
Yeah. However, Emily, what I want, the STEM extension rule says two things. One, the university must be accredited at the time of extension. Also, STEM extension is only possible when the person is in the OPT period. So since the person is not in the OPT period, the person probably is out of luck for the STEM extension. But for those people who have the OPT valid right now, they can apply for STEM extension. I don't see any reason why they cannot apply for the STEM extension right now.
I don't think that would apply to anyone though, because they would have, if they didn't graduate in before December of 2016, most likely they switched to a different school already. No, and fell out of, and the OPT would have ended in December 2017.
You're right, but I'm speaking of those people who graduated from December 16th to right now. Let's say they graduated in December of in April of 2017, and now they have 1 year OPT. They still have a OPT period. Yeah. They can still apply for the STEM extension, even though at the time of graduation their university said it's not accredited. The Department of Education now says that all the ACICS universities are accredited going back to December 12th of 2016. So coming back, even though graduated in April of 2017, they can still apply for the STEM extension as of now. We still have to see how the courts will interact on that. Emily, how in the EVC model, if the end client does not mention the employer's name, will it cause any problem for the H-1B approval?
Yes, I would say you're likely to get a denial.
What is your experience on it, and what it used to be there when the end client was not, previously the end client was not giving the letter mentioning the employer? We used to get the approval in 2016. What happened? Why is it so different right now?
Well, we have a new memo now that really is looking at the entire succession of contracts. And USCIS will say, we need the end client to acknowledge that your company exists in order for us to verify that the employer-employee relationship is maintained properly with your company. So if the end client letter does not mention the actual employer by name, I think it's going to be tough to get that H-1 approved, unfortunately.
Vijay has a question. He has a textile engineering degree and he has 10 years experience in software testing. Will it be any problem for him to get the H-1B extension? What do you see the trend right now for those people whose degrees are in textile, mechanical engineering, civil engineering?
Well, now we don't have deference to prior approvals anymore, so they're certainly going to be looking at your qualifications. So if you got these approvals without any kind of evaluation in the past, I would expect you're going to need one now. With the proper education plus experience evaluation from a qualified service, it's much more likely that you should still be fine. But yeah, it's definitely going to be looked at in more detail than before.
Murli has a question with regards to his I-140 has been approved and he is now moving to a different company. What time limit does he has to file a labor and I-140 application? Now here is a couple of questions I have for you, Murli. Is I'm assuming that your I-140 has been approved for more than 180 days. If your I-140 has been approved for more than 180 days and you move to company B, there is no time limit when you can file labor and I-140 with the company B. You could be filing in 1 year, 2 years, 10 years. You can extend the H-1B based on your previous I-140 approval. You can get the H-4 EAD with your previous I-140 approval. Your previous company's withdrawal of the I-140 will not have any negative impact in what I told you about the H-4 EAD, H-1B extension, and porting the date to the new company. But one condition that I want you to remember, that the I-140 must have been approved by more than 180 days.
All right. Do you see any issues with someone switching from H-4 to F-1? Will they be able to get the visa if they're traveling and come back on F-1 if they've been in H-4 before?
Yes, I do see a lot of problems with when H-4 people move to F-1. If they apply for H-4 to F-1, we do see that things go through very smoothly here. If they go to India to get the stamping, we do see a lot of problem. One major issue that comes up, the difference between the H-4 and F-1, is that for a H-4, if the person has an intention to permanently settle in United States, that is not a bar for the person to get the visa of the H-4. But when it comes to the F-1, if the person's intention is to settle in United States, then that is a bar for them to get the F-1 visa. The problem with the USCIS or the State Department is that every person who is making an application is presumed to have an intent to settle in United States. It's like telling in a criminal law that you're presumed to be guilty unless proven otherwise. That's not the case in the criminal law, but when it comes to the immigration, you're presumed to. What about the premium processing, Emily? Is premium processing still active, or is it? Can people do premium processing, and what do you expect about the premium processing with regards to the quota?
Right, so everything other than the lottery cases can still be filed in premium processing. Everything's going through smoothly. I have not noticed any delays in getting receipt notices or email notifications for all other cases. So that seems to be like we won't see another version of last year where everything got delayed and they stopped issuing things in the 15 days. And I don't think that's going to happen for the non-lottery cases. For the lottery, we are pretty sure that we won't be able to upgrade until September. The question is, will they be processing applications this whole time? Based on the current processing time, I mean, it's taking more than 6 months. They're still working on cases filed last fall. They're still working on cases filed last April. We still have a couple hanging around. So will they be able to process any of these CAP cases and get them approved before October 1st without the premium processing? I think that's everybody's guess right now. We'll just have to wait and see. I'm assuming they're going to be starting to process some of them, but they're definitely not going to get through them all by October 1st without premium.
In the quota cases, for those people who have filed, do not plan to travel between April and October. There are a lot of issues with it. Of course, Reddy Newman PC has been always advising do not travel because consulates are always, there is a good chance of denial there. But when it comes to traveling, while the change of status is pending, you are abandoning the change of status application. Before you make any travel plans, I would like you guys to discuss one-on-one with your lawyer if you could travel. If so, what are the conditions that you need to follow? Do not make any travel plans if you file a change of status application from F1 to H1.
All right. Nadish has a question about experience letters for the I-140. What can you do if you can't get an experience letter? Will they accept affidavits? I actually have a blog post about that. I believe it's called Documenting Experience Without Experience Letters for I-140s. And yes, you can generally document experience through other means. An affidavit by itself probably isn't enough, and it probably shouldn't come from you. So it's going to have to be from a former coworker there, but it's got to be supported by secondary evidence such as W-2s, pay stubs, offer letter, any other kind of documents that you might have. But it may be possible to still get the I-140 approved even if you have an employer that no longer exists or may not be cooperative. I saw another question about the 60-day grace period.
Yes.
Are there any eligibility requirements for that?
Well, one is that the I-94 validity should be there for the 60-day grace period. If the I-94 is not valid, particularly we face a situation when the person extension gets denied, then the 60-day grace period is not applicable because the I-94 already expired. But if you got laid off or you move from one company to another company and your I-94 validity is there, the 60-day grace period can be used from moving from one company to another company. We are seeing a kind of liberal interpretation with regards to the 60 days at this point of time. We haven't seen much denials on that though.
All right. Aditya was asking about any delays in getting the H4 approvals when it's filed with the H1. Yeah, I would say that we're having difficulties sometimes getting the H4 approval, or sometimes the online case status doesn't update at the same time the H1 case status does. And then there's a few day delay between us receiving the H1B approval and the H4 approval. So it's definitely not out of the ordinary. I would give it a little bit of time and see if it eventually comes in the mail. Otherwise, a service request is probably going to be necessary.
We're noticing particularly in Nebraska Service Center where people file an extension without any change. That's where we see a lot of problems because Nebraska is not accustomed to handle the H4 plus EADs. So that's what, but mostly in California and Texas Service Center, we see good results there, Emily.
All right. Arun has a question about the 6-year maximum and recapturing. So is there any minimum amount of time that you can recapture? Say your current I-94 is valid until August, but you have an extra 30 days that you could recapture. Can you extend for just 30 days? The answer is yes, you can. Whatever time you spent outside the U.S., even if it's a short time, you can file an extension for that period. Now, whether your employer is going to be willing to pay for it for such a short period is another question, but there's no minimum requirement from USCIS for being able to recapture.
Sujana has a question. Can I continue working with company A even if my H-1B has been transferred to company B? Can she still continue with company A?
Yeah, at that point, you've got 2 H-1B approvals. You can choose which company you want to work for. You don't have to join company B just because you filed a transfer with them. You can stay with company A. Same goes if you've switched to company B and company A wants you back and hasn't withdrawn that petition, you could potentially go back to company A. It's called a dormant H-1B. And so you could have more than one H-1B approval valid at the same time and pick which one you want to work for.
Emily, with regards to the denial percentages that is going on the H-1Bs, on the H-1B amendment, extensions, transfers, and the new quota, what was the story in 2016 to compare to what is the situation right now? Have we noticed more approvals than 2016 or less approvals? Or can you comment anything on the denial percentages?
I don't have any numbers to back this up. I would say the percentage of denials has increased a little bit, but I think that it's really more the RFEs that increased a lot, and then people are still able to get approvals after the RFE. In a lot of cases, there are more denials in general, but I don't think it's like thousands more compared to what it was before. I think that people have figured out what USCIS is looking for and are getting better at filing stronger cases in order to get the approval.
Can I go to India for stamping while my I-140 processing is pending? In general, the answer is yes. You will not have any problem in stamping just because your I-140 is pending. That is not going to be any problem. However, we have to warn you that at this point of time, there is great danger when you go for stamping, irrespective of what your conditions are. We're noticing a lot of 221Gs and a lot of denials that I have never seen in my 23 years of immigration practice. So it's when you, and if you plan to go travel, sell everything, go there, you get the stamping, you come back. Otherwise, you stay back. Please don't call there crying and whining because you have an option of not traveling. I don't know how to emphasize every single day so many families are destroyed by going to India for stamping.
Manoj has a question about filing a transfer. What will happen if the current employer is going to withdraw the H-1 next week and the transfer is not filed yet? That's where the 60-day grace period comes into play. So as long as you have the validity of your I-94, even if your employment is terminated and the previous employer withdraws the H-1B, as long as the transfer is filed within the 60-day grace period, you should still be fine.
Emily, Preetham has a question. How much time it takes for the USCIS to reopen the motion for the H-1B denial? Can the person work while the motion to reopen is pending? Are there any other alternative options other than filing to motion to reopen?
The motion to reopen can take anywhere from 2 months to 8 months, even longer. There is no set processing time that they're required to process it in. So if it is actually successful and it is reopened, doesn't mean it's going to get approved. A reopen could just result in another RFE and then a denial after that. So the processing time is very long. A motion to reopen does not provide you any status. It does not provide you any work authorization. So no, unless your previous H-1 has not yet expired, you aren't technically authorized to work. If you did work and the motion is ultimately successful, then you are fine, but that's a big risk to take, especially for such a long period of time while you're waiting. In a lot of cases, rather than filing that motion or filing an appeal, if you have the option to refile with premium processing, that may be a much faster, better way to get back into status rather than waiting for a motion for months on end.
Sanjay has a question. He came on a visiting visa, a B1 or B2 visa, and then he converted into F1, which was approved. Now he wants to go to India for stamping. But if that's a one-way ticket, don't buy a two-way ticket. You're not coming back. The probabilities of you coming back is less than 5%. That's a statistic show, because when you change from B1 to F1, you change the status. The consulate hates you because they think so that you pretended all the way to settle or to study in USA, and then you use the B1 visa. Now that might not be true when a person is coming on an F1 visa and converting into H1B. The consulate might not hate that person as much, but they hate the people who converted from B1 to F1. If you're going, you might plan to go one way.
All right. We have a question about I-140 withdrawal versus a I-140 revocation. So an employer can request a withdrawal of an I-140 anytime for any reason. An employer cannot revoke an I-140. What happens when an employer requests an I-140 be withdrawn, USCIS will then revoke the I-140 because the employer requested the withdrawal. All that to say, even if that happens under the new regulation, that's not so new anymore, January 2017, as long as that I-140 was approved for 180 days, you can still get the priority date, you can still use that I-140 for 3-year extensions of your H1, you can still get the H-4 EAD for your spouse based on that approved I-140, even though it's been withdrawn and revoked. Now, what is an actual I-140 revocation? That's a situation where USCIS looked into the details and maybe found there was a misrepresentation or some kind of fraudulent action or documents during either the labor certification process or with the I-140. In that situation, that is an actual revocation. When that I-140 gets revoked, you can't use it anymore for anything. You don't get the priority date from that labor certification. It's all gone. So in general, in most situations, the I-140 is withdrawn, and that leads to a revocation, but that revocation doesn't really have much of an impact now based on the regulation from last January.
The problem is when the employer withdraws the application, the USCIS in its withdrawal letter says that the I-140 has been revoked. However, I just want to note here, as Emily was pointing out, if it's revoked for wrong reasons other than employer withdrawal, any fraudulent filing or anything like that, they will issue an intent to revoke the I-140 to give an opportunity for the employer, and in some cases the employee also can respond to those things. That's when if the revocation occurs after the intent to revoke, you are in trouble. But if the employer withdraws after 180 days, you are pretty safe. I don't see any problem for you.
All right. There was a question, I don't see who asked it, but what is the grace period following the denial of an H-1B extension?
If the I-94 is valid, Emily, they have a 60-day grace period after, if it's an extension, the most question that if the I-94 is valid, it's 60 days after the I-94 is expired. But if the if the I-94 is valid, they can still continue working on it. But if the I-94 is not valid and the extension has been denied, there is no grace period. One more time, because I confused the audiences, is that if the I-94 validity is not there, the extension is denied, you do not have the 60-day grace period.
Can you get a labor certification and I-140 filed for you while you're in H-4 EAD?
Absolutely. That's a very good question. You can file on the H-4, you can file a labor certification, you can file an I-140. Absolutely no problem. We have done several times, and it's just nothing odd about it. It's just common. Anybody can file a labor certification. So H-4 people can file on an EAD. Absolutely. Those people particularly who have used up their 6 years of H-1B, if they are on H-4 right now, they are fearing that the H-4 EAD will be gone. This is the right time for you to file an I-140 application. Emily, can we discuss about this employment-based green cards backlog? Previously we said EB3 was backlogged. Now EB2 is backlogged very much. Now EB1. I mean, even if you are a Nobel Prize winner, just because you are from India or China, you're backlogged by 6 years. 2012, even for Nobel Prize winners. What do you think is the future of the employment-based green cards? Do you see any relief or any legislation that is there?
Well, without legislation, I don't see any relief in sight. I think that with the Trump administration wanting to get rid of the H-4 EAD, there's nothing good coming that would help people that are stuck in the backlog through regulation or through the Trump administration, which means that we have to rely on Congress to actually change the law in order to solve this situation. I mean, these laws were created when the World Wide Web was just coming out. We didn't even call it the internet back then. The DNA sequencing hadn't been done on the Human Genome Project yet. We didn't even have Dolly the sheep yet at the time when these immigration laws were created, yet we're stuck with them. Regardless of what's happened in the world, what's happened in the United States, where the need is for workers, the current law doesn't care. Now, there are some bills out there that might fix the problem. HR 392 is one of the top ones, and its counterpart in the Senate. The problem right now is, even though there's a lot of co-sponsors, there's still not enough support, there's still not enough urgency for Congress to actually bring it for a vote. I mean, if they actually brought it to the floor, when you have that many co-sponsors, it's sure to pass, but you've got to get it to the floor. I mean, we're in a situation where, the length of the line depends on where you're from. I mean, what kind of country allows that? It's just not fair. And
isn't there in the Constitution you cannot discriminate based on the country of birth, Emily?
Right, yeah. It is definitely a discriminatory system. I don't think it was intended so much to be, and people that are change, it's going to flood the system with people all from one country. Well, you know what? All those people are already here. There's no flooding of the system. They're all here on H-1B. We're not changing anything. We're just letting people move on with their life. So I think that there needs to be a lot more urgency, a lot more push to our representatives to get them to actually act on this bill. It's a proposal that's got more support than I think any other bill in who knows how many years, yet it's not going anywhere.
We recommended the audiences to use the support letters that we have drafted in rnlawgroup.com, especially to support the HR 392 bill, to write letters to the congressmen and senators so that this discrimination against Indians and Chinese has been taken off.
Jitendra had a question. We kind of covered it a little bit, but let's say your I-94 has not yet expired. You filed your H-1B extension early, which is what we recommend, and now you've got a denial, but you still got 3 months left on your I-94. What can you do? You can file a transfer, you can file a change of status, you can even refile the extension if you think you can overcome the grounds of denial. That's the reason why we recommend filing your extension so early, and please file it in premium processing. Don't wait the 8-month-long processing time to end up with a denial after your I-94 is expired. File it early so that if things go wrong, you have the ability to fix them before your I-94 runs out.
Emily, so you said that if the I-94 is valid, you can file an extension, you can file a transfer, you can file an amendment plus extension too. So,
or a change of status.
Or a change of status. But are they not available when the I-94 expires?
Correct, they're not, because once your I-94 expires, in order to extend your stay, in order to transfer, in order to change your status, you always have to prove that you're maintaining your existing status on the date of filing. So once
whoa. When we file premium processing, it's an automatic denial. Is that true, Emily?
No, definitely not. Regardless of whether it's premium or regular, if it's going to get an RFE, it's going to get an RFE no matter what. It's not because of premium processing. Denials are not because of premium processing. I think that people get that sentiment because They're upset that they just paid $1,225 to end up with a quick denial. But I think you would get that same denial no matter what, based on what I've seen. I see very little difference between premium and regular.
Emily, as thousands of people are waiting for their lottery receipt or getting in there, are you going to update your blog like the way you did it previously every day? How much percentage of the people got the receipt notices from each service center? What are the categorizations?
Right. Yeah, we do have some of our initial data entry as far as what types of cases we filed this year, whether they're advanced degree, master's cap, or non-advanced degree or bachelor's cap. And we will be posting probably daily as checks are cashed or as receipt notices come in, so you can see where you're at in the process when you might expect to hear back on either a receipt notice or a rejection notice.
Is there any risk if you are doing stamping through Dropbox? Yes. In fact, I just got off the call from a client who did a Dropbox. They called for the interview. They denied their H-1B. This is a very common thing that is going on. Dropbox is not a guarantee that you're going to get the visa. It's just an option the consulate can use when they want to, and they can not use it when they don't want to. So if you put in the Dropbox, they might call for it, and that's going more frequently than what it used to be about 9 months ago, 10 months ago. Let's wrap it.
I think so. Yeah, I think we've pretty much covered most of these questions. So if you asked a question and didn't hear an answer, you might want to go back and listen from the beginning, because a lot of the questions we covered throughout. And if we didn't get to your question this time, feel free to join us next time.
Thank you. Next week, the live Facebook Live is going to be Tuesday at 5 p.m. Central Time. You can come back and post your questions. We'll be answering most of those things. Thank you guys for logging into Ready Newman PC Facebook Live.